I am so excited about a recent case that came out from Ontario Court of Appeal.
Yeah.
You know why. Let's talk about it.
Look, I have to say, since we started our podcast, Max, how long? 4.5 years ago, we have been overly concerned with junk science and bullshit expert evidence.
We've had
one of which
Elizabeth
was
Loftus on here. We've
real experts. Okay,
Yeah.
We had real experts on memory, and we've been concerned about a certain psychologist who's called out by the Crown to testify about the neuroscience or neurobiology
of
trauma, and how, alleged victims of abuse will encode and then be able to recount their experiences. And we've been very concerned about this for years.
For the specific reason that this is a reverse science intended to show how things that would normally undermine the veracity of a complainant's account are now being turned into signs of trauma by this so-called neurobiology of trauma. They say all these things, inconsistencies, inability to recall, all of these hallmarks of things that would make it unsafe to convict are now being turned into signs of proof of rape.
Yeah, well, in essence, it would be, these are consistent with the trauma that a victim would experience, and therefore, if this particular witness, you can argue as a counsel, has experienced these gaps in memory and these particular issues which align with the expert evidence, this therefore bolsters their credibility. That's what it comes down to.
And to be clear, the individual who testified in the case that we're about to talk about, she's not the only person who testifies about neurobiology.
No. We're not singling this one person out.
And she's not the creator of this whole neurobiology of trauma.
And look, she may be accomplished in her academics. That's not the issue. The issue is that her and other people like her who testify on behalf of the Crown is misplaced, not necessary, misleading, and very prejudicial to a fair trial.
So we're going to talk about expert evidence and what the parameters are and where it's allowable and why it's not allowable for certain things. But to start out, the case that we're referencing is called RVPJC 2025 ONC 196. So that's Ontario Court of Appeal. You can go online on canley.org and you can look up the decision on your own. It's quite a fascinating case to read through and thorough.
It's an excellent case. Justice Rouleau writes it extremely well. Mm-hmm. So for those who are not lawyers, frankly, I think this reads so fluidly that it's very understandable even to a layperson. So it's extremely well structured and laid out. And I think I commend it to anybody to read, especially if you're in this business. But let's talk just generally for a moment so our viewers understand expert evidence and the parameters of what expert evidence is and how it's admissible. And generally, let me just say this. Expert evidence is admissible in trial proceedings, generally on hard science issues where it's outside the purview of the trier of fact. And so we've had case law in place for a long time, one of which was Mohan, about...
Oh, can you please say who you're citing?
I'm citing a case right now, so I will in a moment.
But you're reading from Pachoko's
Yes,
Law of Evidence.
I'm reading from the Law of Evidence, 8th edition, Justice of the Court of Appeal, David Pachoko. Okay, so yes, I'm definitely reading from him, but I have the Mohan decision, and I have the other decisions with me as well.
Pachoko, me. We'll talk later.
Okay. He's always excellent, but... So Mohan laid out a number of factors. So the 4 factors were: expert evidence must be logically relevant to a material issue. The expert evidence must be necessary to assist the trier of fact in the sense that the expert deals with subject matter about which ordinary people are unlikely to form a correct judgment without assistance. The expert evidence must not run afoul of any other exclusionary rule, apart entirely from the expert opinion rule. Expert witnesses must be properly qualified in the sense that they possess special knowledge and experience going beyond that of the trier of fact in matters testified to, and in the sense that they are able and willing to carry out their primary duty to the court to provide evidence that is impartial, independent, and unbiased. So just to understand, expert opinion evidence is presumptively inadmissible, and it can be admitted by the calling party if it satisfies these 4 elements. But in addition, once those elements are satisfied, based upon other case law, the opinion evidence has to meet other factors. And rather than take you through the long, because there's the case of Abbey, ABBEY.
I have something to add when you're done.
Another decision afterward, which is White Burgess Longville versus Abbott and Halliburton Co., which was the Supreme Court of Canada decision. It basically comes down to a second tier of tests. The judge must also consider or conduct a cost-benefit analysis balancing the probative value of the evidence against its prejudicial effect. And that's the White Burgess Longville Inman versus Abbott and Halliburton Co. test. And that's 2015 SCC 23, 2015, 2 SCR 182. And I just want to put it this way. The reason I'm just going through this is there's been a long history of case law, Mohan, Abbey, others, and then this other case from the Supreme Court of Canada, which has laid out basically a 2-part test, and it's important to follow. And the reason for that is there's stringent rules in place and specific rules with respect to how evidence is relevant, expert evidence is relevant and admissible, and you have to have a properly qualified expert. You want to say something?
Well, I wanted to specify that, like, experts being called in relation to sexual assault and trauma, that there's been a large number of decisions coming out in which they said that it is not required for experts to testify that, quote unquote, real victims might not report straight away, real victims might not act in an avoidant behavior, that experts are not required for this because it's now being accepted by the courts that, that it's accepted and generally understood that those rape myths are not things that people consider so much anymore. And judges, more specifically, if it's a jury and not just a judge alone who already knows these things, that judges are totally capable of admonishing juries against engaging in those typical rape myths. So we do not need experts to explain typical rape myths to juries anymore.
We don't. And this is something that's very important. This we can't equate that with that. So there has been discriminatory beliefs that have been in the system for a very long time. And over the years, both based upon, general understanding of how true victims of violence behave, which also coincides with, sociological and psychological evidence, we understand that these discriminatory beliefs are wrong. That's fine. But we don't need to call expert evidence on that. We have dealt with these discriminatory beliefs and ungrounded assumptions, if we want to call it that, based on developing case law and our understanding of how real victims behave. This is different. So I just want to be careful about this, okay? Expert evidence is a very important area where, if it's abused, can lead to wrongful convictions. We've had, the inquiry into Dr. Smith.
Wrongfully convicted. There's a good book talking about how this type of stuff, it's a little bit older, but it talks about how expert evidence has led to wrongful convictions. And that's not the only one. There's a bunch of other books out there specifically talking about this. And this one mentions specifically a case of a Dr. Smith. It's a different kind of expert evidence in that case, but it led to a whole bunch of wrongfully convicted people in the cases of shaken child syndrome, and he was a pediatrician,
versus murder,
right? Yeah.
Murder. He's a pathologist. He's a pediatric pathologist. Look, it's a whole other area to go into.
Different area.
But he was a piece of shit who basically lied and fabricated evidence and came up with his own opinions, and he was not checked by others. It was extremely bad, part of our criminal law history, where lots of people were convicted based upon his evidence alone. But it's just a perfect example how when somebody has the trappings of an expert with impressive degrees and experience and articles written, that they can become overwhelming for a jury. So it's very important that courts remain vigilant in scrutinizing what can be admitted as truly expert evidence. And generally in criminal law, the admission of expert evidence is fairly circumscribed. You know, we have it in true hard science, toxicology, for example, blood alcohol or testing for substances, and you can have that in many types of cases. Impaired driving, sexual assault cases when it comes to capacity, pathology, medical evidence for, you know, in murder cases or others with respect to injuries.
Those are technical testimonies about
Biological evidence.
What's viewable and seeable and examinable as a physician or a doctor of some sort, versus simply bolstering testimony.
90% of the time, you can replicate the work. So when
psychology is a little bit different than what you're talking about, the hard sciences. You know, psychology is testimony about how some people may or may not think, and how some people may or may not act based on what they may or may not be feeling. And that's how does an expert testify on behalf of another person what they may or may not have been feeling, thinking, or, or deciding for various reasons. And so that's
right. So just again,
so that's a big difference in terms of like soft sciences versus hard sciences.
Yeah. So in many cases, if you have certain biological evidence, DNA, toxicology, you can replicate the science and you can replicate the tests. Defense can hire experts to address it. This is very different. So this is what we call a soft science, where you're dealing with psychology. They want to refer to it in many respects as, almost a science with respect to memory and encoding and recall and trauma. It's really not. It's a soft science, and you can't replicate it in the same way you would what we refer to as a hard science.
And in this case, PJC that we started talking about, this particular expert witness never actually had psychological sessions with the complainant. She was literally testifying about what she had read in pretrial testimony and what she thought a real victim would react to in certain circumstances. So there was no actual analysis, no investigation, no, scientific study done.
Well, so that would be a problem in any event. So I would advocate that would be inappropriate. So yes, she never met with them, and this is, let's just frame this properly so everybody understands, okay? So we're dealing with a certain psychologist who's testified a number of times in some very high-profile cases about the neurobiology or the neuroscience of trauma and its effects on memory, okay, period. So this is a person who has a PhD in psychology and may have other experience with respect to neuroscience, and it's an individual who does not individually assess the complainant who's testifying for the Crown. Their evidence has to be objective. Now, if you call an expert on behalf of the Crown who's then assessed the complainant, their evidence will no longer be objective. Their evidence will then be testifying on the ultimate issue in the case.
Right.
They will literally be testifying about what this complainant has experienced and why. That is not permissible.
And the credibility.
By impact, it will be the credibility.
Yeah.
So that's on the ultimate issue, which is whether they should be believed or not. So that is 100% inappropriate and cannot happen, and thank God has not happened.
Yeah, so originally this expert was qualified on giving evidence of the neurobiology of trauma, including the encoding, storage, and retrieval of memories. And as we've discussed before, and I think is generally known, memory science is not really absolute. It's not a hard science. That she was supposed to provide biological explanation of how people recall traumatic events. And that's a biological, and we've seen before in another case we discussed how this type of biological terminology can actually become more confusing than helpful to a judge or to a jury. And that was the case in Hogard, where they found it actually to be more complicated. And there was, language being used which could be considered to be scientific jargon, such as impaired semantic encoding of memories. Yeah. So there's a question
this was a case dealing with childhood sexual assault. So that again needs to frame it, because how a child would encode and remember events separate and apart from what an adult may.
It's been known for a long time that children can't be expected to testify in the same way that adults do. And so then that becomes one of the core questions. Do we need an expert to bolster the testimony of the child? And I think when we get to it, like examples of hypothetical questions put, changed it from just generic information about what you can or can't expect from children. And again, the question is, do judges, because this was a judge-alone trial, do those judges need to know that, or have they already been educated on it? And then the second is it doing anything other than just bolstering the complainant's evidence?
I want to just go through the case and sort of break this down so that everybody understands, and I think it's an important case. So in this case, the psychologist authored a report and analyzed various portions of the complainant's interviews and preliminary hearing testimony, and described them as being consistent with how victims of childhood trauma would remember traumatic events. For example, her report discussed the phenomena of what you said, impaired semantic encoding, and illustrates it by referring to a particular answer by the child. And they gave one example. The report notes, when asked by the detective whether the accused ejaculated, the complainant responds that she doesn't remember. The expert went on to explain that the concept of ejaculation is not something a child of 7 can be expected to understand. Failure to remember whether the accused ejaculated or not is an example of impaired semantic encoding because as a child, she most likely did not understand what ejaculation is. Pause. So you raised this issue. Duh. Okay? So without this scientific verbiage, it's not, we know that a child who would be 5, 6, or 7, or even 8 might not understand that terminology, might not remember appropriately. We certainly don't need an expert to dress this up as having impaired semantic encoding. So that's just a good example of how this type of evidence in a report can lead to a skewed finding. Mm-hmm. Because all the expert does is support that the lack of memory on this particular issue means more than likely that they are telling the truth.
The testimony is targeted at the things that might cause people to have a reasonable doubt. And another example of this is testimony from this expert talking about dissociative amnesia. That's the quote, dissociative amnesia.
Well, that's one of the things that she could talk about, but...
it's one of the things mentioned, right? So it's a gap in memory caused by an individual detaching from reality to cope with a traumatic event. Well, this is an assessment not given by an expert who's actually given therapy to a client to say that they experienced this thing. This is an expert saying, this would be a reason to not be worried about this amnesia or lack of memory. It's totally separated from an actual expert's diagnosis, but it's intended and offered in this case to explain away the things that would cause you to raise a reasonable doubt.
Okay, so first of all, when you're calling expert evidence at a trial, does it automatically go into the trial, or is there a pre-hearing for it?
Well, they had a pre-hearing in this.
I know, I just want to explain it to our viewers.
Yeah.
So evidence is called on a voir dire, first of all, to determine if it's admissible.
There were limited challenges in this case by the defense, but there was some challenge.
Well, what does that mean, just so everybody understands?
So, the Crown has to apply to bring an expert in to give testimony, and they delineate the things that they're supposed to testify about, and then the defense can offer their submissions on whether they approve or disapprove of that expert, and then the judge will decide, sometimes and quite often with limitations, on what the expert can testify about. You can testify generically about something, but you're not allowed to testify. Usually this is the result. You're not allowed to testify on the specific facts of this case.
Yeah, and you're never supposed to do that, because again, that's the ultimate question. So again, a voir dire is a hearing within a hearing. The expert evidence is called on the voir dire. The Crown presents the evidence, the defense is allowed to cross-examine on it, and then you make submissions as to whether it's admissible or what portions of it may be admissible and to what point. And again, what you said is they can't testify on the ultimate question, which is why the complainant may or may not be believable.
Right.
But you can put to, if it's deemed to be admissible at trial, you still can argue the weight about it later on, meaning what's its import. And the Crown can then put in the evidence during the course of the trial, not by asking specific questions about the complainant's evidence, but by a series of hypotheticals.
Right.
So this is very
That's
important.
where we get into mischief with this case.
Right, but we need to explain what these hypotheticals can be, what's their purpose, and then how it can cause a problem.
So let's get into the hypotheticals because they outline them very clearly in this case. Which
I
again,
understand,
you can go look up online. So
again, just to explain to everybody, so you can put a hypothetical to an expert. So if A would have experienced B and therefore is of such an age, are they likely to remember X, Y, and Z, or something of that nature? These are hypotheticals, not necessarily based on the evidence of what you anticipate to call as the Crown in a case, or you can do that as the defense if you're calling expert evidence.
But in this case, what they found in the Court of Appeal was that during this voir dire, the Crown put a series of questions to the expert based on purportedly hypothetical situations, but each of these referenced a hypothetical child that incorporated distinctive features of the exact complainant's evidence that was going to be offered at trial.
Right, so this is an important point. So let's take one hypothetical, for example. Yeah. Hypothetical 1. A child approximately age 7 is able to recall being raped. Multiple vaginal rapes. Is not able to recall whether ejaculation took place. Expert answer. The expert testified that semantic encoding of that event would not be possible. A child would not have a cognitive understanding of ejaculation, so they would not encode that memory. Now, the hypothetical, factually speaking, was identical to the evidence of the complainant
being alleged by one of the complainants
at trial.
Yeah.
So, and in this case, it's important to note, the first witness for the prosecution was the expert. Then the complainant testified. It's more appropriate to have the expert testify first because you don't want the expert to then be opining on the evidence that's already been heard or the trier of fact to then try and relate it back. The problem was, in this case, with the hypotheticals, was that the Crown literally put the evidence of the complainant to the expert through hypotheticals, therefore already bolstering the credibility of the complainant before the complainant was ever called.
I love hypothetical too, because in this case, it wasn't a child who was testifying. This is an adult who was testifying about events allegedly having taken place as a child.
Yeah.
So they said, hypothetical to the expert, a child is repeatedly assaulted, sexually assaulted, and physically assaulted between ages, say, 7 to 9, and is now an adult. Is that person going to be able to give us exact sequence, number of events, the time frame when the events took place? Expert answer, the adult in question would not be able to provide this information. That's a pretty solid answer. Would not be able to. I'm sorry, would always not be able to? Would sometimes not be able to? Did you even interview this person? No.
We don't want them interviewing, though. That's also the problem. You know, not only have they not interviewed, they have to remain objective. If they are then involved in assessing the actual complainant, they have now stepped beyond what would be objective, unbiased evidence. They're now testifying literally to bolster the credibility of the complainant. When you think about this question, child is repeatedly assaulted, sexually assaulted and physically assaulted between the ages of, say, 7 to 9, and now is an adult. Is that person going to be able to give us an exact sequence, number of events, etc.? Like, this is stupidity, okay? It is so misleading to do this. I'm actually shocked that this was called a trial. Because if I was the judge, I would have shut this down.
Should have been shut down. Yeah.
Shut it down. This is not appropriate because this literally tracks the evidence of the complainant. And we now, and you would know the entire purpose of this is to literally bolster the credibility of the complainant.
And, you know, the other examples are really good, but I think we can kind of summarize them by just looking at what the response was.
We don't need to go through all of them, but I think the hypotheticals are important.
The statements, though, to other hypotheticals are, yeah, that would be consistent with how someone would describe dissociating. Exactly. So that would be how someone, a generic someone, right? And then this is highly consistent with how dissociative people talk about their experiences and what she sees in childhood sexual abuse cases including historical sexual abuse cases. So this is a comparison to other cases that this person has allegedly looked at that are not before the court, and is being compared to that and saying, yeah, they all look consistent to me. This looks fine.
So the trial judge ruled after the voir dire that the evidence of this expert was clearly relevant to the issues in this case, and that the expert was qualified to give expert evidence on the neurobiology of trauma. The trial judge also found that the expert's evidence did not violate any exclusionary rule, as she did not opine inappropriately on the credibility of the complainants. The evidence was necessary since the issue of encoding, storage, and retrieval of traumatic memories is complex and nuanced, and can assist in putting into context the evidence of the complainants. And Dr. Blank, evidence is outside the knowledge and experience of a typical Canadian person.
Only Canadians, so apparently. I'm just sorry, it's funny because they say Canadian person.
Well, we're excluding the United States right now because of tariffs. The trial judge concluded that Dr. X's evidence ought to be admitted because it provided an explanation for the
Right, this is important. This is important.
slow. Because it provided an explanation for the inconsistencies or gaps in the evidence of the complainants. She then specified she treated as only one factor that she considered when weighing the evidence in his trial.
That is what that is what this evidence was designed to do.
Yeah.
In terms of bolstering the complainant's evidence. It was designed to be an explanation for the inconsistencies and gaps in the evidence of the complainants. So the prosecutor knew there were inconsistencies and gaps and brought this expert, which they didn't have to do, brought this expert in order to bolster the case. That is what happened.
And the judge literally admitted it.
Yeah.
Because it provided an explanation for the inconsistencies or gaps in the evidence of the complainants. Now, correctly, the judge noted, it's only one factor, but as you read the decision, it was a lot more than that, and it was literally used to bolster the credibility of the complainant.
Otherwise called oath helping.
Oath helping, and this is extremely egregious.
There's another section that really stood out for me, where when the court's in discussion about the evidence and the admissibility factors, they said, I'm at paragraph 29, in my view, the expert's evidence ought not to have been admitted. And I will explain, it did not meet the necessity requirement for the admission of expert evidence. Further, the way in which it was presented went beyond providing context for understanding the complainant's evidence. Through the use of hypotheticals tracking the specific allegations and behaviors of the complainants, the expert's evidence improperly bolstered their credibility and served to blunt any prospective cross-examination of the complainants. Accordingly, even if the evidence had been necessary, it should have been excluded because its prejudicial effect outweighed the probative value it may have had. So, blunting the prospective cross-examination. Let's talk about that. What does it do when you have an expert who comes in, because the expert in this case testified prior to the complainants, right? So the expert comes in and you cross-examine them before you've cross-examined the complainants. And then when you go to cross-examine the complainants, how can that blunt the cross-examination of the complainants?
Well, the expert evidence has blunted the cross-examination.
Because
period.
You can't ask certain questions anymore.
The expert has already testified that a series of cross-examination, 1 through 10, is already not relevant because the inability of that complainant to testify in a consistent manner or remember certain things is perfectly consistent with having been abused. Mm-hmm. So your point of cross-examination is blunted.
And if you try to get into any areas that they've already blunted with that expert testimony, then you'll be shut down.
No, you won't.
You just...
No, you can still, you're going to cross-examine on it.
Right.
100%.
Doesn't matter anymore.
Let me go back a bit. So in this case, for example, trial counsel did not specifically object to the admission of the psychologist's evidence, but did argue that the evidence cannot be used to bolster the complainant's credibility. And what we have to remember is the trial judge, regardless of what's stated by the defense or the Crown, remains the gatekeeper of the ultimate evidentiary rules. And so there is a duty to be vigilant and assess and exclude inadmissible evidence regardless of the positions taken by counsel. So even if a judge rules that the evidence may be admissible for X, Y, and Z, the judge still, if they miss that point properly, the judge still needs to be careful about assessing how the evidence can be used. And then counsel, if they're in this situation, would still go down the road of cross-examining on all of the traditional areas you normally would, having in mind when you're dealing with somebody who experienced something as a child, you have to be nuanced and understand how to deal with this. And therefore, minor inconsistencies is never going to carry the day. But you're going to be mindful of this, but you're still going to go down the road of certain areas of cross-examination. And at the end of the day, you can still make submissions, and the judge has to understand that it has but one role or one factor in the overall analysis. It wasn't that in this case. That was the problem.
Yeah, I think there was a good point made. They say that faced with experts' impressive credentials and mastery of scientific jargon, jurors are more likely to abdicate their role as fact finders and simply turn to the opinion of the expert in their desire to reach a just result. In judge-alone trials, the need to draw the line properly between the role of the expert and the role of the court remains an animating concern when determining the admissibility of expert evidence.
Well, that's what we talked about when we said that, you have to be very careful with expert evidence, because when you have it dressed up with a PhD or a medical degree and having written several articles and opined on various issues, that can then usurp really the analysis of a trier of fact and a jury. And that's the danger. And that's why I love the analysis in this case so much. So let's just go to that for a moment. So the judge who wrote the reasons for the Court of Appeal stated, in my view, Dr. X's expert evidence ought not to have been admitted. As I will explain, it did not meet the necessity requirement for the admission of the expert evidence. Further, the way in which it was presented went beyond providing context for understanding the complainant's evidence. And this is what you referred to, through the use of hypotheticals tracking the specific allegations and behaviors of the complainant. Dr. X's opinion evidence improperly bolstered their credibility and served to blunt any prospective cross-examination. Accordingly, even if the evidence had been necessary, it should have been excluded because its prejudicial effect outweighed any probative value it may have had. I give limited weight to the fact that no objection was made by trial counsel to the admission, and then the court goes on, as they appropriately should, that it's up to the judge to be the gatekeeper of the evidence. And again, I think this is important to emphasize. Whether the defense specifically objects to the admissibility of expert evidence, it does not impact the trial judge's responsibilities as a gatekeeper. That's extremely important to remember. The judge must be on guard to protect against the admission of inappropriate evidence.
One of my concerns as well is that the Crown can bring an expert in at the cost of the state, and if they want to challenge it or bring a counter expert, an accused person has to pay themselves personally to counter that evidence. And that really causes me concern, how we should not allow Crown to willy-nilly throw around experts who aren't actually required, because it increases.
And by and large,
expense.
they don't. I mean,
they usually don't. But
no, they don't. I mean, this is the only area where expert evidence in recent times has been such a horrid problem. It has been exactly this type of evidence. I mean, I can imagine where there's some testimony on some novel science, but by and large, where we have seen this play so much mischief is in the sexual assault area. Let's just talk about necessity for a moment so people understand.
Yeah.
So, again, opinion or expert evidence is presumptively inadmissible. And it's well established that witnesses may testify as to facts, but as a general rule, may not give their opinion about those facts. Experts are often described as exempted from this rule, but it's only when the trier of fact is unable to form a correct judgment on the matter without the help of an expert that their opinion evidence will be properly admitted.
Meaning there's got to be some sort of specialty to the information they're offering.
there has to be a particular special knowledge that is necessary for a trier of fact to be able to come to a correct conclusion. And what you said, and I just want to take it in sequence here, the primary danger posed by the admission of expert evidence is that faced with an expert's impressive credentials and mastery of scientific jargon, jurors are more likely to abdicate their role as fact finders and simply atone to the opinion of the expert in their desire to reach a just result. In judge-alone trials, the need to draw the line properly between the role of an expert and the role of the court remains an animating concern when determining the admissibility of expert evidence. So, it has to be a fairly exceptional set of circumstances where the expert evidence has that unique degree of special knowledge to assist a trier of fact in arriving at what would be a just conclusion. And even if it's a judge-alone trial, it has to be circumstances in which that evidence has that unique function. Mm-hmm. And they are the gatekeeper. So in a judge-alone trial, it's very important at the outset to determine admissibility to make sure it's absolutely necessary and admissible.
You do want to put people in the position where they say, well, who am I to disagree with the expert on whether or not this person is telling the truth? Right? Because the ultimate finder of fact is the jury. And like we said in this case, this expert didn't even interview the complainant, knew nothing about these complainants, and was just talking generically about what was believable. That's what makes this case so unique, in a way, is that because we have had cases with expert testifying about battered woman syndrome, and they did do minimal interviews, usually about an hour. But in this case, there's no knowledge of the complainants whatsoever, just generic questions, substituting that expert's opinion about what they should find believable and what they shouldn't.
Okay, so let's drill down on this for a moment. Yeah. So why in this case was it admissible, and what was the problem here? So there's no doubt that an expert who's a psychologist or a neuroscientist about memory encoding may very well have evidence that is admissible, because generally the neurobiology or neuroscience of the brain may be something that's helpful to explain why people who suffer trauma as a child or adults may have gaps in memory. Yes, that may be true. And it may help to some extent explain the context in which why a particular person with these experiences may or may not remember things. But the question that the trial judge in this case, and in other cases that's similar, should have asked is, in the present case, can the judge correctly assess and interpret the complainant's testimony without the help of the psychologist's evidence? In other words, was an understanding of the functioning of the brain, the neurobiology of trauma, and the semantic encoding, amongst other things, necessary to assess whether the three complainants were credible, whether their evidence was reliable? By equating helpfulness with necessity, that's where the trier of fact erred. So this is really important. It was helpful, but it was not really necessary.
It's potentially helpful, but the way it was targeted and the way it was used was incorrect. I think they summarize it, like I'm on page 23, paragraph 50, and they mention a caution from another case that it was cautioned that hypothetical questions posed to an expert should help the court understand the features of behavior generally, but not invite a court to accept each complainant's evidence regardless of their conduct and notwithstanding the weaknesses of their testimony. This manner of eliciting expert evidence ought not to effectively mask the weaknesses of each complainant's testimony and to cloak it with a semblance of scientific reliability. Right. And I think that is a really great quote, because that's precisely what was happening. And they go on to say, this is precisely what the hypotheticals put to this expert did in this case. They put to her, scenarios that would cloak the testimony of the complainants in scientific reliability.
Yeah, what happened was basically, craftily, the Crown put to the expert witness through hypotheticals, asked the first witness in the trial, evidence of the complainants that would be testifying next, where there would be inconsistencies or inability to remember certain things, to the expert, who would then explain it with scientific certainty why that is not an issue and why the person would not be expected to remember. That is incredibly problematic. if I can put it lightly.
It's a roundabout way of simply asking the expert to say, are these complainants telling the truth?
See, exactly.
Really,
You might as well have just read. You might as well have just let the person testify, then take those portions of evidence where there's inconsistencies or lack of memory, put it to an expert and say, is that believable or not?
Right.
And the expert goes, no, it's totally believable.
Yeah.
That's exactly what it was.
Yeah, so they're essentially getting the expert to testify to the veracity of the complainant's evidence.
But we should not
That's
forget,
what we can't allow.
We shouldn't forget also the caution that was also provided by the Court of Appeal in the Hogarth case, that the actual terminology and science and all that other rhetoric and bullshit that came out was so unduly and overly complicated that it
wasn't even helpful.
It just misdirected the jury, and the jury was then trying to reverse engineer the evidence that they heard to match with the expert's evidence to then arrive at a conviction.
Well, trying to understand, in that case, they used the curative proviso because they found that the proper corrective instruction was given limiting how her evidence could have been used in that particular trial. So they found that it didn't actually affect the outcome. It's being appealed. But the Supreme Court used the curative proviso. In this case, it was a little bit different. It went way beyond.
No, in this case, it literally went to the if I can say it this way, in this case, it literally went to the ultimate question.
Try to usurp the judge's role. It
clearly did. I mean, and the judge fell afoul of, unfortunately, whether the judge regarded this as one factor, the essence of this was that the judge unduly relied upon this to bolster the credibility of the complainants.
And not just because the expert gave that testimony, but because the way the judge referenced that testimony in the decision. That's important.
Well, yes, that's why I'm saying. They referenced it in such a way that it ultimately was bolstering the credibility of the complainant, and the path and the egregious nature of these hypothetical questions was enough for this to go back for a new trial. But this is important. So there's a lot of paper on my leg here. And that is, the courts have spent many years, over courses of decades, trying to get the correct tests with respect to the admissibility and relevance of expert evidence. And we must remain vigilant and careful to not let, evidence in that will just cloud the analysis is not really something that a trier of fact must have to be able to properly assess the evidence. And we have to be careful about that. And finally, between the Hogarth decision and this decision, we're finally putting to rest this issue about the neurobiology or the neuroscience of trauma as being beneficial evidence in sexual assault cases. It's not beneficial, and you can see how it's
dangerous.
You can see how it's ripe for abuse. But you can see how it's ripe for abuse.
Absolutely.
And the use of these hypotheticals was a perfect example of that. And that's why we got to be vigilant and careful. And when you're presented with expert evidence in a case, carefully think about it. What's its purpose? Does it really help? And then how can you attack it as being admissible?
And thankfully, this case will help people out who are fighting this type of situation in the future.
I think the door is shut on this stuff.
Great decision by Ontario Court of Appeal.
Yeah, very well written too. I mean, sometimes cases are harder to read than others, and as lawyers we know how to read it. This is an extremely well written decision.
Which is why we like explaining to you. And if you like, having these things explained, don't forget to like, subscribe, comment, share, tell all your friends, and leave comments because we do read them, and we love your suggestions for topics that you want to hear about.
Good night, everybody. Thanks very much.